the law webinar. I'm Sam Clark, and I'll talk you through what we're going to do in a moment. But before then, can I ask that if you have questions for us, and we will do our best to answer questions either at the end of the webinar or as we go along, whoever isn't speaking, we'll try to answer questions. If we can't answer them, we will try and signpost you afterwards if we can, or find out. There might be some things you ask that we just don't know. So, but if you are asking questions, can you use the Q&A bit, not the chat? So if you look, hopefully along the bottom of your screen, there is a bit that says Q&A, and that way we can track the questions. What tends to happen is if they go in the chat, we lose them. Or it can happen so fast, but please do share with each other or us anything you think is useful, or you want to you know, kind of share with others or comment on. You're very welcome to use the chat, but if you've got questions, please put them in the Q&A bit along the bottom of your screen. I hope it is there. So we're recording this, just so you know, and we will share it. So welcome again. I am Sam Clark, and I'm from Learn Disability England, and I'm going to start the webinar today just sharing with you all so that we're checking out. These are some of the things we're hearing, and what we're hearing is tricky for people. And then Alex Rupkeen, who is a barrister and a lecturer, and he will explain that much better than I will. He's going to talk about what we think the law means for some of this. So hopefully we've had amazing feedback when we've done webinars with Alex before, so hopefully it'll be really useful to you all. So I now can't move my slides on, but that's not a problem. So I just want to remind you all that Learn Disability England primarily works with people with learning disabilities and their families and their paid supporters, and we exist to work out what we can do together to make people's lives better. So a part of this webinar for us is about those shared issues, those things that we are hearing from all of our members about what matters. And what the reason I put this slide in is because through COVID, it's become more clear how much we all agree on and how much we're all struggling with. Because everybody, pretty much all of our members, want the same things about a good life. So what we're hearing from people, we are hearing from people that everyone is finding it hard to tell the difference between what is the law and what is guidance. What must you do, and what are you advised to do? And if you don't do it, what could happen? So we're hearing that from lots of people. Which is it? Is it a must do, or is it a would be good to do? And connected to that is, what decisions can you take for yourself? And what happens if somebody can't make that decision? So we're hearing quite a lot, and Alex will talk about it much better than I will, about what happens when somebody else has to make decisions, or when people are having to make decisions for groups of people because it's their job. The things we're particularly hearing from people with learning disabilities and their families is, somebody asked us, who decides if someone can leave their residential home? So we specifically asked that question. Who decides if an autistic person can leave their residential home? We've also been asked, what if someone cannot self-isolate because it will make them really distressed? So we're being asked that by quite a lot of families and supporters, paid supporters. What if somebody is not necessarily very ill, but is experiencing, has been, you know, had been contacted through track and trace? What if? And then we also got a question about, how can people balance the stress of not doing something with the infection risk of doing it? And I kind of slightly reworded, but one person before this webinar sent us an email talking about their absolute joy of being in crowds at football matches. and what it does for them and the difference it makes to them and how it helps them deal with life and with stress in an enormous way. And therefore, they aren't just missing football in a way that some people might, but they're missing something that helps them make sense of life. And I thought that was a really important point, because it isn't just about the football, is it? It's about those things that help all of us. That there will be lots of examples of that. And then in the last 2 weeks, the other thing we've heard quite a lot about is adults with Down syndrome being added to the list of people who are extremely clinically vulnerable. Does this mean that if somebody with Down syndrome doesn't have lots of other health problems, they're really otherwise healthy? Does it mean they must stop work or going out or doing things? And lots of people have been talking to us about that. Lots of people are really concerned about it. Towards the end, I'll send you a list of links, and we'll send out the slides, by the way. I should have said that. I'll send you a list of the links for where people have good resources. And the Down Syndrome Association are getting lots of contacts about that. And if that directly affects your life, do talk to them and do check out their resources. They're doing lots of stuff on that. But it's a really important question for lots of other people, I think, as well. And then we've also heard questions, particularly from paid supporters who work in places, especially where they're supporting people in shared living settings. So that might be people who are working or managing residential care, but it might also be people who are supporting people to live in shared houses with all sorts of different names. But it's the shared bit that's really challenging people. And that we've had questions about, what if someone will not agree to a coronavirus test? So what if somebody can make that decision for themselves and won't agree? What's other people's roles? What does the law say? What if someone cannot make that decision? And particularly, we've had lots of questions around that, where people are worried about how difficult they think that will be for somebody. Because I don't know if any of you have had a test. I've had a test, and it isn't easy. I don't want to put any of you off, but it's a bit tricky with the one with the man with the thing in your mouth. It's doable though. And then we've had loads and loads of questions, and I know it's a massive challenge to thousands of people. What are the laws or the guidance that we must follow to help people see their family and friends? What if someone lives in their own home? What if someone has a tenancy in a shared house? What if someone lives in residential care? Those kind of issues about people not being able to see people who are important to them and they love have been the thing that we've been contacted most about, probably this year. So they're the kinds of things that we've been hearing a lot about and having direct questions about. But we've also had quite a lot of questions or people contact us about loads of worry about do not resuscitate decisions. What can someone do? What can't they do? And I've put a picture there because Turning Point worked with Learn Disability England on a pack to help people understand their rights. But this is still a big worry for lots of people. But linked to that is a real set of questions and concerns about who makes decisions on treatment. What if someone is ill? And how do we get ready for if really hard decisions are needed? And what are the different rules and laws that we might need to think about as a family, for people themselves, or for people's paid support teams? So we are going to share the slides afterwards, and I'm not going to talk you through all of this, but there are things out there to help us all. We will share a link to these. And I think there is growing resources that can help us work our way through it, but it is tricky. But now I've shared with you what we are hearing, I'm going to hand you over to Alex, who's going to talk to us about what is the law and what is the guidance, and help us think about some of the things we need to consider. Thanks, Alex.
Brilliant. Thank you so much, Sam. Thank you for inviting me. And I've enjoyed doing things with Learning with Disability England, the webinars before, and have been very challenged in different ways. I mean, both because it's a challenge to try and relay some of the law. It's also a challenge because the questions and the comments which come back, in particular from individuals with learning disabilities, are so appropriate and right, and frequently not actually possible to give a very good answer to. One of the best challenges, or one of the best questions we had at one of the webinars is, when is this all going to be over? And what an enormous question. And we don't yet know. And actually one of the things on that question, and almost the only sensible answer I could give, is we don't know, but a lot of the guidance, and the law, and we'll talk about a bit more on the difference in a minute, are suggesting things that people try and do so that we can try and make sure that this is over as quickly as possible. And that's why there's so much around self-isolation. That's why there's so much around making sure we don't come into close contact with people. That's why we're trying to, until a vaccine turns up, assuming one does, really all we can do is try and make sure that we are as careful as possible in terms of seeing each other. That's the one thing that seems to be able to stop the virus spreading, which obviously just then has the most enormous knock-on implications for all sorts of people where they need to see each other. I mean, both just to stay happy, stay well, and also where people can't then understand, well, why am I not allowed to see someone? So that's one of the sort of overriding themes. So let me just, Sam said I'd talk about who I was. That's who I am. I've got a range of things. Basically what I do is I'm a barrister. For those of you who don't know the difference, a barrister is a type of lawyer with us, barristers and solicitors. Barristers tend to be the people who might go to court. So sometimes I go to court and argue cases. I actually spend most of my time now not going to court and arguing cases. I spend most of my time now doing a lot of work around policy, a lot of work around training people, a lot of work around, in particular, trying to ensure that health and social care professionals are legally confident and legally literate. So in other words, they understand the framework within which they're meant to operate. So what we're doing now is an exact counterpart to that, which is not only are people on this call who are trying to operate in a legally literate way, hopefully helping you out. It's also for people who might be engaging with professionals to make sure that they're able to ask the right questions. Well, why are you suggesting that? Why is that decision being made? Because asking why is a really important tool. Can you tell me why it looks like there's a blanket restriction? Blanket restrictions almost invariably are unlawful in one way or another. But unless you know to ask, well, what's the evidence for this? So that's what I spend a lot of my time doing. I need to give a very boring couple of caveats. One is I can't give you legal advice. I'm afraid I'm just not allowed to on the facts of an individual case. So if there are questions which come up in the Q&A bit which are about specific cases, I'm afraid I just can't give you advice. I can maybe give you some tools to help think. Sam and I can also help coordinate in terms of if it looks like there's somebody you might need to get individual advice about, we can provide sources for that, but I'm just not allowed to. The law doesn't let me. Also, and frankly, as much as anything else, this is for reasons of time. I'm afraid I'm not really, and I know at least one of you I saw on the hello from wherever we are, one of you is in from Wales. I can't cover all of the law in each of the bit of the UK as things stand. I've got to focus on, I am focusing on England. Obviously the broader principles and things like the Mental Capacity Act applies in England and Wales. But the how, and one of the things we've learned over the length of the pandemic is how each nation within the United Kingdom is going about things in very different ways. So I'm going to be predominantly focusing on England. I'm also predominantly going to be focusing on the position in relation to people over 18, because it's when you hit 18 that in normal circumstances, that's the point at which you have the right to make your own decisions, unless you don't have capacity to make them, at which point we've got other decision-making frameworks. If you're under 18, the position is more complicated because parents have got certain decision-making rights and certain decision-making responsibilities. So I'm really going to be focusing on over 18s, predominantly in England and Wales, but we will cover stuff which is a broader application. So I wanted just to remind you of what hasn't changed in relation to the law. Because one of the things that people are very kind of concerned and stressed about is, well, there are so many new bits of law flying around. There's this thing called the Coronavirus Act. There are these regulations, these lockdown regulations, which keep appearing and changing in different ways in England and changing in different ways in Wales, Scotland and Northern Ireland. What hasn't changed? Well, the Human Rights Act hasn't changed. So that's a piece of law which tells people working on behalf of the state, and also in some circumstances the state when it's engaging with purely private individuals, how it is that they're supposed to operate. The European Convention on Human Rights is a set of rights for individuals which explain what you're entitled to. The right to life. The state has to try and secure your right to life. The state can't simply lock you up arbitrarily. That's the right to liberty, Article 5. The state has to try and secure your right not to be subject to inhuman or degrading treatment. That's Article 3. And also the state can't collude or carry out acts of inhuman or degrading treatment. One of the things though, and also it's got to respect autonomy, I should have said. Autonomy, Article 8, European Convention on Human Rights, it's an aspect of the right to private life. And the state has to respect family life, and obviously that's a hugely important aspect at the moment. But it is massively important to understand, and it's one of the things I spend longest trying to help people think through in different situations, and COVID has only really increased this. Human rights is a balancing act. The Human Rights Act and the European Convention on Human Rights are explaining why public bodies are doing what they're doing, trying to keep people alive, trying to secure their right to life, trying to prevent them living in circumstances of inhuman or degrading treatment. It's explaining why the state is trying to do things, but in ways which aren't arbitrary, which don't just simply go around locking people up, don't simply go around not thinking about people equally. So not discriminating. But one of the really, really challenging aspects of COVID is, in a way that we never really had to do before, we are having to grapple with the fact that it's not just individual rights which are in play. So in other words, if you've got somebody, say, in a care home who really, really needs to see their family, if the only way that that can be achieved is by a family member coming into the home, that family member is going to be carrying some level of infection risk. We can try and minimize it, but there is going to be some level of infection risk. And if COVID-19 spreads within a care home, or COVID-19 spreads within a shared lives accommodation, say, the consequences will be potentially fatal, not just for the individual who we're looking at, but for other people around them. And we never had to think of human rights in that balancing way before, not just the person and their family, it's other people who may not be related to them at all. And that's one of the reasons why, and I am not here on behalf of the government, and I am certainly not here to defend the government, but that's one of the reasons why there has been such complexity, such difficulties in terms of decision making, trying to balance things. And the visiting guidance in relation to care homes and the guidance in relation to, for instance, visiting in other forms of residential care, supported living, shared lives. That's why that guidance, so often you would look to it and say, well, why can't it simply say everybody should always be supported to see their families? It can't, because that would be to go too far and not acknowledge that there are going to be risks in that. And it's about how one makes those individualized decisions in relation to the person in the context that they're in, to try and balance all of these things at the same time. If you want to know a bit more about thinking about how balancing of human rights goes on, that website there, knowyourhumanrights.co.uk, is a fantastically good website. It's established by the British Institute of Human Rights. It's free, and it's a resource designed for people who might be on the receiving end, say, of a Mental Capacity Act assessment, or the receiving end of a Mental Health Act assessment. But it's just as useful for people who are trying to act in a Human Rights Act compliant way. Public people working for local authorities, for clinical commissioning groups, for NHS bodies, for care homes who are trying to operate in a way which is human rights compliant. It's a really helpful, concrete tool. So as I said, the Human Rights Act simply hasn't changed, but the way it's operating and the really difficult balances that are going to be required have been made much more difficult by COVID. What else hasn't changed? The Equality Act. All the duties on the state and other bodies to make reasonable adjustments to respond to the needs of people with different impairments, whether that be learning disability, whether that be some form of physical impairment, whether it might be a combination. The state needs to respond. It hasn't changed. The Mental Capacity Act has not changed. If you happen to be listening in Scotland, Adults with Incapacity Act. In England and Wales, Mental Capacity Act, it simply hasn't changed. The core principles about thinking about decision-making capacity, and if someone doesn't have capacity to make their own decision, how to make best interest decisions, that hasn't changed. And I want to talk a bit more about that in detail in a minute, because as Sam says, there's been so much confusion around who gets the right to make decisions. The other thing which hasn't changed, and please bang the drum, bang the drum, advocacy duties haven't changed. IMCAs, IMHAs, Care Act advocates, those duties haven't changed. So what's the difference? And Deborah, you asked a really interesting question. We'll come to it at the end. I'm gonna just on this, for this session, I normally do more interactive. This one, I'm just going to relay information, and then we will ask questions and answer questions at the end. So thanks very much for putting that up, and we'll come to it. So what is the difference? Because this is one of the big confusions. What's the difference between law and guidance? And as Sam says, this is not a confusion which is limited to individuals with learning disabilities. So this is a confusion which goes across the piece. A certain Dominic Cummings might possibly have fallen into that confusion of what the law is and what the guidance is. So let's just break it down as simply as we can. So what is the law? The law is what Parliament has said, has passed, which means you have to follow it. It's a set of rules. And if you don't follow the law, you might be committing a criminal offence. That's, in this context, what the most important consequence is. So, examples of the law, the lockdown regulations. In England, the regulations, the most recent version came in on the 5th of November. That's our lockdown 2.0, people have been calling it, running to the 2nd of December. And those regulations say you are breaking the law if you leave the house without a reasonable excuse. Leave the place of living without a reasonable excuse. There's then quite a long list of reasonable excuses, and it's also important to understand it's not what's called an exhaustive list. So it's not saying the only reason that you can leave your house is for X, Y, and Z reasons. It's saying these are reasons, but if you have another reason to be outside the house and it's reasonable, you're not committing a criminal offence. But the starting point is you're committing a criminal offence. And it's not just you can't leave the place you're living without a reasonable excuse, it's also that you're not allowed to gather together outside or inside in specific ways. Outside you can meet up with one other person, inside you're simply just not allowed to meet up with more than one other person, unless they're there, for instance, to work or to provide care. I'll come on to that visiting aspect in a little bit more detail in a minute. But the starting point is that. You're not allowed to do that, go out, leave your house, and you're not allowed to gather unless you've got a specified reason for doing it. The number of people who are prosecuted for doing this is very low, but the consequence of being outside of your house without a reasonable excuse or gathering in a way that breaks the law is you are breaking the law and you could be committing a criminal offence, you could be fined. The other regulations which are very challenging, and luckily there's a bit of guidance which makes them slightly less challenging in the context that we're concerned with, which I'll come to a bit later, are the self-isolation regulations. So the regulations which say if you've been told by NHS Test and Trace that you are positive, COVID positive, or you are a close contact of somebody who is positive, you have to self-isolate. It's not a choice, you have to for the 14-day period. So you would be committing a criminal offence if you didn't self-isolate. How does that work with people who cannot comply with that? Not don't want to comply, but can't. We'll come on to that. I do just want to flag, I said I'll talk more about visiting in a bit, but I do just want to flag here, the law doesn't prevent visits in care homes and hospitals unless a care home has been shut down in terms of accepting visitors by a Director of Public Health. Otherwise, there is no legal bar on visiting. But here, as in elsewhere, we've also got guidance. We've got bucket loads, that's a technical term lawyers sometimes use, bucket loads of guidance coming out from different people. Most obviously in the context we're concerned with the Department of Health and Social Care, they are publishing lots of guidance, visiting guidance, guidance for people working with individuals in supported living placements, all sorts of different kinds of guidance. The guidance means you should follow it. As an individual, you should follow it because this is what the government is trying to do to try and minimise the impact of the pandemic and bring it to an end as soon as possible. That's at an individual level. If you're an organisation or you're working for an organisation and you don't follow the guidance, you may not be able to say you are making the right sorts of decisions. It doesn't mean you're breaking the law, it just means that if someone challenges and says, well, why have you gone ahead and, as it were, for instance, barred all visitors, even at end of life? The care home, if it's a care home, would be in real difficulty saying we could properly do that when the guidance itself, the visiting guidance, makes clear, even in the most restrictive circumstances, visits should be allowed in exceptional circumstances at end of life. So examples of guidance include the visiting guidance for care homes and hospitals and the shielding guidance. I'll put it in inverted commas because it's not technically called that, but the shielding guidance including, and I'll talk a little bit more in a minute about the guidance for those considered clinically extremely vulnerable. And as Sam says, one of the things which has caused challenges recently is that list of people who are the government considered to be clinically extremely vulnerable. In other words, if they get COVID, it's very likely to be very troubling, very difficult and possibly fatal. That list has now been extended to include adults with Down syndrome. And we need to think that through. So that's the law and guidance. So just thinking about decision making, I just want to take you through this in a little bit, as it were, overview, and then drill down into it in a couple of different areas. So the first principle is that the person should be supported to make their own decisions. That's the most important principle in the Mental Capacity Act. You can't say that someone lacks capacity to make a decision unless all practicable steps have been taken to support them to make that decision without success. So the various things which might be in play, which might be relevant, so testing, we need to try and make sure that individuals are supported to make a decision as to whether or not to undergo a test. Flu vaccination, I can't emphasize highly enough, we need to be making sure that wherever possible, flu vaccines are being administered to ensure, not least, that people aren't suffering from flu at a point when they might get COVID. Also, to make sure that we don't overwhelm the health system even more than we might be with people who are getting flu in circumstances where they might have been eligible for the vaccine. And then also self-isolation, the need to self-isolate under guidance if you think you've been infected, and also if you've been told by NHS Test and Trace that you should self-isolate because you have been tested positive or you're a close contact, you should be supporting the person should be supported to make their own decisions. If the person can't make their decision, the decision-making framework is governed by the Mental Capacity Act. So let's just run through who that might be making a decision there. It's possible that the person themselves might have made an advanced decision to refuse treatment, to say, there might be a point where I can't make my own decisions, and I know what it is that I don't want. There are ways in which those can be created. There's certain things which have to be gone through if it's about life-sustaining treatment, but that's a person saying, this is what I don't want. And if they've made one and it's valid, no one else can override it. I can't emphasize strongly enough, and I'm going to come back to this, that should be reflecting what the person themselves is saying, not what other people are saying about them. This is the person's own choice. It might be that there's an attorney. The person themselves might have been able to grant a power of attorney to make decisions about health and welfare or about property and affairs. But let's really think about health and welfare. They might have done that, in which case it's the attorney's power. The court might have appointed somebody, a deputy, to make decisions on their behalf, in which case it's the deputy's decision as to whether or not, for instance, to agree or not agree to a medical treatment. Otherwise, it's meant to be a collaborative process between everyone who might be concerned to identify what's in the person's best interests. The way the Mental Capacity Act works is not meant to be saying one specific person gets to make the decision. In practice, of course, it does start feeling like that, because if a doctor's got to make a decision about, for instance, whether or not to administer a treatment, ultimately the doctor needs to know, am I protected, which is how the Act works, is the doctor protected against what would otherwise be a charge of assault if they provided a treatment to somebody where they hadn't consented. The doctor can only be protected if they reasonably believe the person lacks capacity and they reasonably believe they're acting in the person's best interests. So it starts feeling like the doctor is a decision maker, but that's simply because the doctor is the person who would otherwise be criminally liable. That's how the Mental Capacity Act works, and it's sometimes difficult to kind of get your head around that. But the critical thing is it's not meant to be, I'm simply imposing my decision here in relation to this individual. It has to be thinking about what's in their best interest in a collaborative way. I do need to emphasize one urban myth, which is always out there, and every opportunity I get to try and stamp on it, I have to do. There is no such thing as the next of kin in the context of the Mental Capacity Act. Just because the hospital might say that you're somebody's next of kin, which really means a communication person, so one person the hospital can communicate with, does not mean you get to make the decisions about whether or not your loved one gets a medical treatment or does or does not have medical treatment. I'm afraid it simply just doesn't work like that. And it can actually, one of the real things I find immensely challenging in working with parents of individuals with learning disability is having had a very important decision-making role before they turn 18. At the point that they turn 18, they don't automatically have that decision-making role. And it's a real challenge. But that's how the law works. Unless they've been appointed health and welfare deputy, or unless unless the lasting power of attorney has been granted, which couldn't have been granted by someone under 18, they don't have automatic decision-making authority. The other thing I really need to flag, and COVID has really flung this up in spades, that third bullet point, you can't always get what you want, whether or not you can make your own decisions. I can't demand a medical treatment that a doctor doesn't think is clinically appropriate. I can't demand to go and live in a certain place if my care is being funded by a local authority if the local authority has decided my needs can equally appropriately be met somewhere else more cheaply. And local authorities are allowed to take into account money if they think that the person's needs are properly met in both places. I can't always get what I want, and that's irrelevant. It's irrelevant that I might not have the ability to make my own decision. If I don't have the ability to make my own decision, I still can't always get what I want through people arguing on my behalf. What I shouldn't do, though, is get less. Just because I don't have capacity to make a decision doesn't mean I should be getting any less. I don't get more, but I shouldn't get any less. If there's a dole's authorisation in place for the person to care home, so in other words, the person's been recognised as being deprived of their liberty at a care home, over 18, I just want to lay a marker down here. You need to be careful what you do in terms of, for instance, seeking to remove the individual from the care home. We've seen some very alarming media coverage of stories of people being arrested trying to remove individuals from care homes. I don't know precisely what has been going on there, but the care home doesn't have, as it were, a power to detain the person, but there is a process which has been put in place which recognises these individuals deprived of their liberty there, recognises that it's meant to be in their best interests and necessary and proportionate to the harm they'd suffer otherwise. And if you don't like what's going on, the proper place to go is to challenge that in the court rather than trying to take the law into your own hands. I don't want to sort of talk too much more about that because it gets into quite difficult legal water, but I do just want to lay down that little marker. So just thinking about complying with guidance. If someone's got capacity to make their own decisions, it is for them to decide what to do. But as I said, the guidance is there for a reason. So for instance, the shielding guidance is there for a reason. And when it says in relation to clinically extremely vulnerable people, including now adults with Down syndrome, what it says, including you are strongly advised to work from home. If you cannot work from home, you should not attend work for this period of restrictions. It means what it says. It's saying if you get COVID and you have one of the range of other things which makes you clinically extremely vulnerable, it means that the prospect that you will die, bluntly, is higher. But if you've got the capacity to make that decision, it's not that you're not allowed to go out to work, say, or leave where you're living. It's just not a very good, it's a very bad idea. If you don't have the ability to make that decision, and most of the people we're thinking about here wouldn't necessarily have that capacity, somebody else, other people are going to have to think about making those decisions on their behalf. And it's always going to be balancing to the risk to the person of not complying with the guidance against the risk to the person of complying with it. So in other words, to answer that question in relation to an individual, an adult with Down syndrome, should they be stopped from going out to work, assuming they don't have this, assuming that this is taking place in the context of a framework where the individual said not to have capacity to make their own decisions, should they be stopped from going out to work and going out to visit, or going outside, if otherwise they are healthy, there's no actual comorbidity, they're physically healthy? The balancing act has to be done. The balancing act has to be done of, well, the guidance is making clear it's not a good idea, but there might be some good reasons why actually it is in their best interests. And I know and I understand that the people working, individuals working with adults with, say, Down syndrome, are going, oh my goodness, this guidance now seems to be saying they must just stay where they are, they mustn't go out. That's what the guidance is saying, but in each case you'd have to be balancing up. And actually into that balancing equation also, I've always got to flag, I'm afraid, the potential that if somebody in that context, and I'm not just talking about Down syndrome, but somebody where decisions are being made on their behalf about how they go out, where they go, who they see, and they're in accommodation which they share with others, always somewhere is going to have to be what happens if they bring COVID back with them. We can do everything we can to minimize the risk, all sensible things, but there may just be a residual risk we can't eliminate, especially if the person isn't able to tolerate the sorts of measures which might be put in place, or other people might put in place to minimize infection risk. And if they're going to come back into a place with other people who are very vulnerable, we are always going to have to think about what about the potential impact on those people, because they didn't make a choice that X goes out. They didn't make that choice. But if X goes out and comes back and brings COVID and they catch it, well, think about that position. So it's balancing risks, obviously being sensible, minimizing risks as much as possible, but it is ultimately balancing. Similarly, I've just done for compliant guidance, let's just think a little bit more about self-isolation. If you've got capacity to make decisions about self-isolation, it's your own choice in terms of the guidance which says if you think you've been exposed, self-isolate. But you will be breaking the law if you've been told to self-isolate by NHS Test and Trace, or a public health officer has told you to self-isolate. It's not optional at that point. You're breaking the law if you don't comply. It's up to you if you then want to go off and get a criminal, run the risk of committing a criminal offence. But you are breaking the law at that point. If the person doesn't have capacity, decisions are going to have to be made on their behalf. And again, it's a similar framework for thinking I've just been talking about. But one thing I want to just flag, and it is helpful, I think, from these purposes, the Department of Health and Social Care's emergency MCA DOLS guidance has been updated on a rolling basis. The most recent version was the 11th of November, picking up the local lockdown in England, the England lockdown on the 5th of November. One of the iterations, and it's been cumulative, grappled with the fact that if somebody has been told by NHS Test and Trace, you must self-isolate because you've been tested positive or you're a close contact of somebody who's been tested positive, but they can't understand why it is that they should be self-isolating. The Department of Health and Social Care's MCA DOLS guidance recognises, helpfully, it may not always be in a person's best interest to be required to comply with the self-isolation regulations in those cases. They say it's highly likely it's going to be in their best interests, but the decision maker would need to take into account all the circumstances. And they say in some limited circumstances, it might not be in the person's best interest to follow self-isolation rules, because, for example, to do so might cause them severe distress or other negative personal circumstances. If they're then going out in circumstances where they really, really should be self-isolating, the guidance goes on perfectly sensibly to make clear, they need to be supported to take all the measures of self-isolation that they can. It's possible for them to do without suffering that level of anxiety and distress. So visiting, so care homes and hospitals, as I said, it is absolutely clear, it is lawful both to leave your house to go to a care home to visit somebody there, and within the care home for there to be more than 2 people together. It's absolutely clear because that's what the lockdown regulations say. Except there are circumstances under which the Director of Public Health, who's a person who works for the local authority, can direct the care home that they have to be closed to visitors, at which point you would be breaking the law if you went in. But that's an extreme end of the market. Almost all of the rest of the time, it's about guidance. The care homes and the hospitals following guidance. There's different care homes for different guidance for care homes, different guidance for hospitals. All of this you can find in a range of different places. All of it as it relates to people with impaired decision-making capacity, I have been gathering on my website, mentalcapacitylawandpolicy.org.uk, in one page of COVID-19 and MCA resources, because it's so difficult trying to keep a handle on it. But I've got all the relevant guidance. And it is important that the government are recognising it's taking a very long time for that to get translated into guidance in the more concrete ways. But the government does recognise, and both iterations of the guidance now in relation to hospitals and in relation to care homes, recognises the importance of visiting to the person. In other words, a hyper accentuated, a really strong version of what the judges have always said: what's the point in keeping someone safe if you merely make them miserable? What we've recognised under COVID is that trying to keep people safe actually has gone, in some circumstances, beyond making them miserable into actually making the situation much, much worse for them. So they're becoming even more unwell. Annoyingly, as a lawyer, there isn't anything specific in the lockdown regulations about visiting people in any other setting. So that would include someone's own home, shared lives, anything else apart from something which is designated as a care home and hospital. So there's no specific exception. Of course, reasonable excuses might well apply to enable you to say, well, I need to be out to go and visit this person. But there is a problem in relation to seeing the person inside, because the ban on gatherings doesn't afford quite the same level of reasonable excuse get round. But one thing I would just flag, the government this is about the only place where the regulations, the lockdown regulations, have recognised the specific needs of individuals with disabilities. It's really challenging that the regulations just haven't been written for people in this context. The ban on more than 2 people being together in an outdoor public place doesn't count. Outside, you're allowed, in addition to the people who are trying to see each other, you are allowed up to 2 carers for a person with a disability who needs continuous care. So that is one, as it were, legal recognition of how important it is that individuals might need support to see family and friends. So that's visiting. Testing. Well, what's the basis for testing? Wherever possible, capacitors consent. I'll just deal I'll deal immediately with what happens if someone's got the capacity to decide whether or not to undergo a COVID test and says no. If they say no, they can be required to undertake one by a public health officer under the Coronavirus Act or that other piece of legislation I put at the end. They can be required to, and if they don't, they are committing a criminal offence. That's how it works. And so it would be a question of, do they have capacity? Do they understand that they're committing a criminal offence, potentially committing a criminal offence? Most individuals were probably thinking more about, do they have capacity to make this decision? No, they don't. At which point, testing is in their best interests. And I can't emphasise strongly enough that bit in red. No blanket decisions. You can have a blanket policy that it's a very good idea that individuals are tested, but you can't have a blanket policy which says everyone is going to be tested whether or not it's in their best interests. The courts have talked about, and we've done a guidance note, and I can show you where to find that at the end. We've done a guidance note in my chambers where I work about testing, where we talk about what the courts have talked about, the idea of being a responsible citizen. So in most situations, most people would probably want to be tested because they wouldn't want to spread the virus. And they wouldn't want to cause harm to others. But we can't automatically assume that, always. And also we've got to be very careful, if it looks like there's any suggestion that the individual might need to be restrained so as to bring about testing. Because at that point, a real legal issue arises as to whether the restraint is lawful. Because the Mental Capacity Act only allows someone to be restrained, and it could be restrained for purposes of carrying out a test. They are only allowed to be restrained where it's necessary and proportionate to the risk of harm that they would suffer if they weren't restrained. And if the real reason someone's being tested isn't for their benefit, but for other people, the Mental Capacity Act kind of breaks down there unless the people involved go to the Court of Protection. The Court of Protection has got a bigger ability to think about risk of harm to others. But outside the court zone, this is definitely an area where people are on very, very thin legal ice if there's restraint being used to bring about testing where the reason to test isn't in the interest of the person, it's in the interest of others. As I say, we talk about it in our guidance note, which tries to thrash this out in a bit more detail. If you're involved in the delivery of testing or coordination of testing, conversely, if you are thinking about a loved one, a family member, say, or a friend who might be undergoing testing in these circumstances, and you are worried about the circumstances, this is where you need to be asking the questions. On what basis are you doing it? How are you justifying it? Why, if you're considering restraint, how is that said to be necessary and proportionate to the risk of harm that X will suffer, my son will suffer, say. So the last bit I want to talk about, and then we'll have a bit of time for questions because I can see them coming in. I've been trying not to look at them so I can just, as it were, finish this bit and then I'll try and make sure I answer them, is about medical treatment. This is just one slide. I have done what I've been calling shedinars. So in other words, I've been doing lots of things from my shed, which is where I am at the moment. I have done one specifically about do not attempt CPR. So don't, if someone goes into has a heart attack, don't try and revive them. Do not attempt CPR notices, and about advanced care planning. I've done a shedinar, it's 20 minutes, it's got slides, it's designed for people who might be having to make decisions in relation to this area, but it's equally hopefully useful for people who might be wanting to make sure that any decisions which are being made are lawful. So you might want to have a look at that and refer people to do it. But this is a kind of one slide about it, just to summarize the things. Because what I'm thinking about here is not the situation whether someone needs the medical procedure right here, right now. We've talked about that, either capacity or best interest. We're thinking about planning ahead. What happens if? And the what happens if conversation and what happens if discussion is really important. But it's really important it happens in the right way. So if the person's got the ability themselves to make decisions and participate, they could make an advanced decision to refuse treatment, but it's got to be their choice. They could say what they would like and wouldn't like. They can make what's called an advanced statement. They could possibly appoint an attorney to make decisions on their behalf. But most of the people we might be thinking about today, I don't want to make assumptions, but let's work on the theory that very many of the people we're thinking about today might not currently have that ability. They might not have the ability to do something legal, to make their own advanced decision about what they don't want, to try and appoint someone to make their own decisions. And then at that point, what we're thinking about is, how do we work out what this person would want? Identification of wishes, feelings, beliefs and values, because best interest decision making under the Mental Capacity Act, the courts are absolutely clear. The Supreme Court made absolutely clear in a case called Aintree and James, best interest decision making starts with the person. What's right for them, around them as an individual human being, not the category of people with learning disabilities, not older people, not people called Mrs. Jim, called Jim in general. It's about that individual. So critical points, the advanced planning, including thinking about whether, if they have a heart attack, it would be appropriate to resuscitate, that has to be done with, not to the person. We have seen a lot of decision making undertaken, and I think, in all honesty, it was predominantly done under fear, by fear on the part of medics in relation to how they were supposed to be operating. They weren't thinking as straight as they should be doing in the early stages of the pandemic. There were a lot of decisions being made, imposing blanket DNA CPR notices in care homes, or making decisions about certain forms of treatment that simply wouldn't be provided. They weren't doing it on an individualized basis. They were doing it to people, not with people. Anything blanket done in that regard is automatically going to be unlawful. It always has to be the case that there's an explanation. But can I please just make one really important point? It is perfectly lawful for a doctor to say, I don't think a treatment would be clinically appropriate. For instance, I just don't think it would work. You can't demand a treatment that a doctor doesn't think is going to work. You're entitled to tease out, to challenge them as to why they think it wouldn't work, but you can't demand it. Where you have to be super careful, and the doctors have to be super careful if they start getting into, well, I think it would work, I just think it's a really bad idea because it's not in their best interest. At that point, you need to be really careful to tease them out as to whether they're making judgments about the quality of life of the individual who's before them. And that last point, you might well see sealing of treatment referred to in medical records. It does not mean a sealing of care. The doctors might say there's a certain bar above which it's simply not appropriate to go. Or having thought it through with you, we don't think it would be in their best interest, the individual's best interest. That does not mean the individual will not be cared for. There is no such thing as a sealing of care. And if people talk about it, you need to challenge them and say, you're not, if you think you're going to stop caring for X, Y, and Z, that's obviously unlawful. It just means there might be some treatments which it's not appropriate to give, or having thought about it, not in their best interests. Those are resources, and Sam, I know it's midday, I'm sorry, I've rambled. I'm very happy to stay on for questions, partly because I know some have come in.
You didn't ramble.
But I just really wanted to do the advanced care planning bit in particular, because it causes so much concern to people.
Absolutely, absolutely. Well, I know
So I can't hear you. That might be my end. Hang on.
Ah. I am unmuted at my end.
Ah, I can hear you now. For some weird reason, I then couldn't hear anything.
Okay,
Yeah.
well, good you can. So thank you. I will, what if I pose a couple of the questions to you, and
Yes.
hopefully people can stay with us and join us. There are two at the end about support bubbles.
Yes.
And one is about if a support bubble, you know, how that might work for somebody living in residential care, and we had some questions earlier about if extra care schemes where somebody has their own tenancy and whatever, whether they might be more like supported living and stuff. But I wonder if that was relevant to the support bubble question.
Yeah, so the difficulty in relation to support bubbles, the legal difficulty in relation to them, so I'm not going to be able to give you the answer in quite the way I think you'd like. The difficulty in relation to support bubbles is they were very, very firmly designed really to deal with individuals living by themselves, linking up with another family or another group of people. They simply, they get quite complicated when you try and work them in relation to a situation where you've got multiple people floating around who feel like they look like part of a household, but the individual themselves wouldn't identify and say, this is part of my household. They just simply, this is yet another example of where the law wasn't quite designed to work with with people in these circumstances. I think the best thing I can say is if you're either an organisation trying to work it out, so to see, can I include a family member within a support bubble, or you're a family member thinking, can I do this? That's the point at where you need to go and, as it were, work it out for yourself, getting your own advice, seeing whether you can lever the facts, you can lever the circumstances within it. Because if you can lever things within the support bubble aspect, that's great, because it then means you're not stuck with some of the things I've been talking about. But one of the reasons I didn't talk about them in any detail, in fact I didn't talk about them at all, is that they're just not really, annoyingly, designed for this.
No, okay, thank you. We have another question about what should happen if there's a lack of agreement.
That's a super good question, yeah. If there is a lack of agreement, so I think that was specifically about mental capacity, And interestingly, there, lack of agreement even by local authority people, which makes it sound like it's, as it were, there's a disagreement between various people in the local authority about an individual's decision-making capacity. The short answer is the only person who can tell you, does Sam have capacity to decide to stay on the line now, or not have the capacity to decide to stay on the line now, is a court of protection judge. No one else can, as it were, impose a consensus and say this person has or lacks capacity. And my single biggest point that I make in every training that I deliver to health and social care professionals is, if you can't agree, if there's not genuine agreement about capacity or best interest, don't pretend that there is. You really need to go and find a grown-up to sort this out. And the only grown-up who can really sort that ultimately is a court of protection judge. I appreciate that's not always easy, but the other point I would make in terms of that question is the responsibility, if it's the local authority who are going to be relying on the fact that the individual doesn't have capacity to make a decision to do things, if there isn't agreement about that, it's their job to take the case to court.
Right.
It's not the family member's job, it's not the friend's job, it's the local authority job, because they're the people who are otherwise going to be possibly acting unlawfully.
Okay. So we've got another question that's about visiting in care homes. Does that cover both care and health settings? So, you know, under the guidance, do they mean if it's social care or health?
There is specific guidance. Well, the lockdown regulations talk about visiting in care homes, visiting in hospital, and there is a legal definition of what constitutes a care home. So it's a registered care home. The law also says you can go and visit somebody in hospital, and there's also a definition of what a hospital is. There's guidance, which is different guidance for hospitals and care homes, reflecting the fact that, I mean, bluntly, the visiting guidance for hospitals is much more pro-visiting, weirdly, than the visiting guidance for care homes, because the visiting guidance for hospitals is much more framed around end of life.
Okay.
It's a bit odd, because obviously not everybody in hospital is going to be dying, but I think the people drafting it were going, quite a lot of the people who we might be concerned with are. But I should say, I am extremely well aware there are a lot of hospitals which are finding it very difficult to support visiting.
Yeah.
Which I would flag up on behalf of the hospital staff causes the most immense anguish to them. It's not just that they're, as it were, sitting there laughing with the doors locked. It traumatizes them to be going, I know X, Y, and Z needs to come in. I just can't do that safely.
Yeah. Okay. So then we've got another question that's about the going out and the rules about who can be with you when you're out. And you said the guidance says 2 people supporting you. And Joe asked, what if somebody, I guess in their support plan, has 3-to-1 support when they're out in the community?
Well, technically, I don't want to give legal advice, but the regulations make it clear that the exception, I'll just go back to it. It says, missed it now. No, I can't find it now. Yeah. In England, you can't be with more than 2 other people. I think it's okay. Sorry, I've just managed to upset myself and then de-upset myself. I'm 99% sure, but this is one of the areas I don't want to go. Please go away and double check for yourself. Assuming that they're paid carers and this is part of providing care to a vulnerable person, I think you're probably safe, because it's part of the care plan, it's part of the support plan. These are individuals who it's so obviously the right thing to do. This bit here is, I think, more aimed at, as it were, a social gathering or some kind of meeting up in the park, as opposed to the description you're giving, that someone, as part of their care plan and part of their support plan, needs to be enabled and supported to access the community on a routine basis. But in order properly and safely for them to be able to do it, they need to be 3-to-1.
Yeah.
So it's a slightly different perspective.
Okay, so we do have several questions about extra care schemes and
Yeah.
where do they fit under the guidance, which bit of guidance relates to them. And I think connected to that, we have a question that says, if you're registered with CQC to provide supported living, does that mean you're covered by the care home guidance?
No, is the short answer. Care home guidance covers care homes. Supported living is something different. So, I mean, you can see the government's fixations in the sense that the thing they've been most troubled about, partly because, well, for a number of reasons, was initially care homes in the sense that we understand care homes. That's why we've got very specific guidance relating to it. We've got guidance which as it were, everything else. And it's quite telling that that guidance hasn't been updated quite as often as the guidance relating to care homes. But unless you are registered, unless you're dealing with a registered care home and there's a specific definition, you are just not within the care home guidance. You're in everybody else's guidance. And the two are not, it's not like there's completely one rule for one and one rule for another. I mean, it's the same framework around thinking about mental capacity, around decision making, about balancing risks. It's not wildly different. It's just there's a different set of framing.
Great. Okay. So I guess that means that the questions we've got about, say, extra care, they will just fall under the other, and we'll be dealing with that under what guidance they can get. Is that right, Alex?
Yeah.
I mean, you know, we know that the thing called supported living guidance hasn't been updated recently. I don't think, has it? So, okay.
I think that what's odd is that I was double checking just before we started, and it says it was updated on the 5th of November, but actually it doesn't read as if it relates to the most recent iteration of the either the care home visiting guidance or the regulations as they currently stand.
No. Okay.
Yeah.
Okay. So I think we're
Can I just answer the question about the transport, about buses?
Yes. Yes. Yeah, that'd be great.
Yeah. So does a person have to wear a mask on a bus if they're disabled and don't have COVID? That's a very good question. I'm sorry. In the range of things I was Sam has posed all those questions, and then I probably should have on my own not have said, let's talk about this. Yes, there are regulations about needing to wear a mask in various places, including public transport. But they make it very, very clear that you don't have to if you are exempt. And you're exempt if you have I'm going to get the language very slightly wrong because I've got it at the top of my head, but it's effectively if you've got a disability which means that you can't support wearing a mask, either because it causes you physical distress or physically means you can't breathe properly, or it causes you serious distress. So it's completely lawful not to wear one. You obviously then get into what I think at one of the previous webinars we were having some really challenging discussions around people. Now most people wear masks on public transport. Why is it that X isn't wearing one? Yeah. And that's particularly so, being blunt, if X doesn't have a very visible disability. And then it's a question of how people, if they're being supported, if there is a support, how people respond to that and try and de-escalate the situation.
Yeah. Okay. Thank you. So we're left with a reminder from Sue that although decisions can't be made by next of kin for treatment, their opinions should be taken into consideration when making a best interest decision.
Oh, completely, definitely. Consultation is with those people most interested in the person's welfare.
Yeah. And
if you've been identified by as a hospital as next of kin, you are, well, I'd like to think you're going to be interested in the person's welfare. Every so often you get somebody who's listed as next of kin who is actually completely uninterested, but that's unusual. I think the point I just really wanted to emphasize, I'm afraid, was the other way around. That you don't get the automatic decision-making right to say, you know, my son or my daughter or whatever should have treatment, doesn't have treatment. You just don't get that when you hit 18. And it's a horrible transition to make. So suddenly the point where the decision-making is meant to be collaborative, it's really meant to be taking account your view as the person who knows most about the person, but you don't get the automatic say-so. The good doctors and the good teams who are the ones who recognize that they are the expert in the medicine, you are the expert in the person, and together, that's when you reach the right answer.
Yeah. Okay, great. So we've just got a couple of things left, and I'm really aware of time, so we're going to have to stop at some point.
Yeah, no, it's my fault. I was rambling on. I'm sorry about that.
No, you were not rambling at all. I found it fascinating. I think others have, from what I've seen in the chat, but people are starting to have to leave us. But I don't know whether Deborah feels that you answered some of her initial question or challenge about how does she balance these issues of once somebody sees their family, other people in the house or the setting.
Yeah, and that question is a very pertinent question, and so the person who's able to ask and has family to advocate and gets more contact than those with more profound disabilities, and she can't seem to reconcile that. It's such an important challenge. I mean, it's a challenge across the piece that the individual who's got someone to speak up for them seems to get more than the person who sits quietly in the corner or is unbefriended, doesn't have families. All I can say is I acknowledge that, I agree with it. It doesn't mean it's right, and it means that people working with the individuals in that environment need always to remember that the quiet one or the unbefriended one, they're going to have their own needs. It's just that they don't necessarily have someone to shout about them in quite the same way.
Yeah. Okay. Yeah. So we've got a couple more questions on MASK, which I think could take us a lot longer. So maybe we'll try in the resources to put out some links about the challenges about mask wearing and whether services can not offer you a service if you can't wear a mask. Just to say, there is nobody needs to give you permission to be to be exempt. You just there is no process. You don't get a form or anything. You are just able to say, I have a disability that means I don't have to. So thank you all so much. We've recorded this, so we'll download the recording, we'll share it with our slides. We really appreciate you all coming and your questions, and obviously working Alex so hard. Thank you so very much, Alex. I feel like we worked you incredibly hard for an hour. Yeah. So thank you, everybody, and we'll send you the stuff soon. And please do give us some feedback on what would be useful for next. Thank you. Bye-bye.